Good morning. Please be seated. We are now at the time set for oral argument in United States against VERDE Ditch et al. Our cause number 1CA CV15-0690. Counsel, as I know you're aware, and I'm sure you've heard me say many times this morning, we are familiar with the record. We have read the briefs, and we have conferenced the case extensively before coming into oral argument, so you can begin your presentations, I hope, at a fairly high level without giving us the basics unless we ask for them. Our recording today will be publicly available within the next few days on our YouTube channel, and you will each have 20 minutes for oral argument. The appellants may reserve as much time as they wish, subject to the watching of their own clock. And with that, you may begin.
Thank you, Your Honors. Good morning. My name is John Smeltzer for the United States. Your Honors, under Arizona Revised Statute Section 45-252C and this Court's decision in Gable v. Tatum, the Gila River General Adjudication, now pending in the Maricopa County Superior Court, is the exclusive forum for the adjudication of water rights within the Gila River system, including the Verde River. The United States is a party to the Gila adjudication under the McCarran Amendment, which is a waiver of federal sovereign immunity and a consent to state court adjudication of federal rights only with respect to comprehensive stream adjudications. Arizona and federal law require adjudication of water rights and comprehensive stream adjudications due to the nature of water rights. Any claim anywhere in the Gila River system has the potential to impact other claims. Only a comprehensive adjudication like the Gila adjudication can protect and bind all claimants and stakeholders in the system. All claims in this case, the claims of all Verde Ditch users, the claims of the United States on behalf of the Yavapai Apache Nation, and the competing claims of the Salt River Project are pending in the Gila adjudication and to be adjudicated in that adjudication in due course.
Let me ask you just one thing, though. The 1909 judgment still has some force, right?
Yes, Your Honor.
Okay. And if we had successors in interest to, let's say, just two of the original five in the 1909 judgment, and they wanted to reach a private agreement about the allocation of their percentage responsibilities, just change it 1%, and it was voluntary. Could they have that confirmed in Yavapai County? Assuming, I deliberately drew that to be the narrowest agreement possible.
I appreciate that, Your Honor. I'm not sure they would need to have it confirmed through the court if it's a voluntary agreement and they're the only users on the ditch. If it would impact other
well, they want to have it binding on their successors and just would prefer to have it memorialized in a judgment. Could they ask Yavapai County for that judgment?
Potentially, Your Honor. Ordinarily, the parties to a judgment are bound by the terms of that judgment. And in order to get relief from the judgment, they have to show that it's inequitable or it requires some sort of change.
Or that they voluntarily agreed to modify it, nobody's going to be harmed, and so that we'd like the court to just accept our agreement.
Sure. And that's obviously not the circumstance of this case.
But it's an extreme hypothetical just to set the boundaries. If that were our case, you would agree that it would not have to be confirmed in the adjudication, but could be confirmed in Superior Court.
That would be true if the parties are not asking for sort of the adjudication of water rights under the law of prior appropriation. If they're just sticking to the rights that were actually adjudicated in the 1909 decree.
So the narrow adjudication you're talking about is shareholder A and shareholder B each have a fractional interest in the water flowing through the Verde Ditch.
Right.
And one of them let's say, has a 10%, and the other one has a 9%.
Right.
And if they wanted to say, okay, I'll give you one of my percentages,
right,
transfer it over to you.
Right.
That would be okay
Well, under the rules, the 1963 rules and the 1989 rules that now the commissioners use to operate the ditch, the rules say that if there's a transfer of a share, the parties shall report it to the commissioners. But they understand there can be transfers of shares in interests in the ditch, right?
Right.
And
they're not increasing any interest or appropriating more water. All they'd be doing is saying, I'll give you one of my shares.
That's correct. And but the critical distinction for purposes of this morning is the understanding that a share in the VERDE ditch is an ownership interest in the ditch. And then under the 1909 judgment, the parties agreed that they would share in the water flowing through the ditch on a pro rata basis.
Okay.
But what the 1909 decree did not determine is their rights in terms of the amounts of water they can appropriate from the VERDE River.
You're saying that the percentage, fractional interest in the water flowing through the ditch, based on their fractional interest in the ditch itself, is not an appropriation of water.
It's obviously they're using that water, they're putting it on their lands. It may be an appropriation of water, or it would be an appropriation of water under Arizona law if it's used on the lands. But what I'm saying is the 1909 decree did not adjudicate their rights based on prior appropriation, the priority dates to
water use,
for the historical water use, right?
Okay.
And so what ultimately this case is about is whether, right, the Yavapai County Court can now do that, can now adjudicate their water rights, their historic water use as it's defined in the memorandum.
But it isn't just their water rights, right? I mean, there are other people involved in this. I mean, there are green lands, orange lands, and purple lands.
Right, green, purple, and orange all apply to VERDE ditch shareholders.
Right. But are all of those shareholders? Every one of them is a shareholder?
As far as those are people that are receiving water or have been identified as shareholders by the VERDE ditch company.
They may be people obtaining water but not be shareholders.
Well, that's one thing that wasn't done as part of this record was to go back through VERDE ditch company records and determine whether these folks are actually shareholders. There's no reason to believe they're not shareholders, Your Honor. The critical thing to understand here is that who is a shareholder, right, depends on going from the 11 original fractional interest holders and having those fractional interest holders convey their shares, their ownership interest in the VERDE ditch to other folks. The rules of the proceedings have always said, or at least since 1963, has said when you do that, let us know so we know who's a shareholder. And presumably VERDE ditch company and the commissioners kept record of who their shareholders are, and presumably they're delivering water to their shareholders. That is a different question from the question of historic water use and where there have been perfected rights along the VERDE ditch.
What if the parties are contemplating a transfer and they're uncertain as to their historical water use rights, and they acknowledge that and say we'd like, as between the two of us, we would like to just resolve it, assuming this is what your historical water right is, this is what I'm willing to pay for it, assuming, and the parties are willing to make an assumption. Is there something that prevents them from negotiating some sort of transfer of property?
I think that's the question that's been asked already in this proceedings. And yes, a shareholder can transfer shares according to the rules of the VERDE ditch company.
But I'm just suggesting if you add in there's some uncertainty, and we're just factoring that in. Right. And we're not adjudicating that. Right. But
and what I would say, the uncertainty would not come from the 1909 decree. Right. The decree says you get a pro rata amount of water consistent with your share. So the language of the decree wouldn't be providing uncertainty. What would be providing uncertainty is the claims of other water users to the VERDE ditch or to the VERDE River and to the Gila River system. And those water users may say, look, what you've been doing on the VERDE ditch with respect to just apportioning the available water, the water you've been able to divert into the ditch, that is violating our downstream rights. And so that provides some uncertainty, but those are the issues. The claims to the VERDE River, to the Gila River system and source that are pending, right, in the Gila general adjudication in Maricopa County within the prior exclusive jurisdiction of that court. And the question before this court is, well, there's really two questions. The one question is this what's being proposed in this memorandum of understanding, does it constitute an adjudication of issues that are pending in the Gila River general adjudication with respect to perfected water rights and whether water rights exist. And then the second question is the issue of continuing jurisdiction, right? The Yavapai County Court ultimately held that, look, I have continuing jurisdiction to do this adjudication under the memorandum of understanding because of my role as master of the ditch. And what we submit to this court is the continuing jurisdiction of any court over any decree is always bound by what is reasonably necessary to enforce the terms of that particular decree.
So the decree says, I'm a shareholder. I've got a percentage interest in the ditch. I've got a similar fractional interest in whatever water's flowing through. But I don't have an appropriation of water. Appropriation of water would occur when I say, I've used, let me make sure I understand this, historical water usage, let's say over the last 20, 80 years, my successors or I have appropriated water to a certain degree. And the amount I've actually used has been appropriated. Now I'm getting a decree from the Yavapai Superior Court saying that's my historical water usage. Is that right?
Well, that's what the Yavapai Court is proposing through the MOU proceedings to get into something that wasn't part of the initial 1909 decree and the agreement, the stipulated judgment to govern the parties. And I would say that the folks that are using water on the VERDE ditch at the moment, I wouldn't say that they do or they don't have historic water use. It's just an issue that's open, right? And it's being adjudicated, and it's a question of who determines whether there's a problem. And of course, the Salt River Project has come in, and they say, look, VERDE Ditch Company, you guys are diverting water to people along the VERDE Ditch who do not have perfected water rights under Arizona law. And that's how this whole thing got started. You had a party essentially outside of the VERDE Ditch, a person or an entity that was not party to the 1909 agreement coming in, not asking that it be enforced according to its terms, right, but asking that something else be done because the delivery and the administration of water according to the terms of the 1909 decree, they claim is allowing folks that don't have historic water or perfected water rights, as they describe as historic water use, for purposes of their water use on the ditch. And again, all you have to do is look at the particular terms, right, of the 1909 decree and inclusive of the orders that have followed to know that what they're not trying to enforce anything within the decree. And I asked the court to look at it another way. None of the VERDE ditch users initiated this proceeding to say that, look, this is unfair to me to have my water delivered according to my shares and on a pro rata basis, without regard to priority of use and prior appropriation, because that's not what their agreement, right? Their agreement was the 1909 judgment, and so they're fine with it. What's the problem here is that there's an outside user, right, the Salt River Project, that says its users are being injured by what's going on in the VERDE ditch. And so there's
downstream users?
Downstream users are, right. So the more water that's being used on VERDE ditch, the less water is going to flow downstream.
My understanding is correct. The VERDE ditch and some of the shareholders and SRP and the U.S. all have claims pending in the Gila River adjudication.
Absolutely, Your Honor. All of these issues eventually will be decided in the Gila adjudication. The reason we're here is essentially because the Salt River Project was impatient with the progress of that adjudication. And
hard to imagine.
Understandably, and we are equally, concerned over the pace of the adjudication. We'd like it to proceed quickly.
I'm curious. By what mechanism has the United States appeared in this case? You mentioned the McCarran Amendment, which applies to the adjudication. Has it waived sovereign immunity for the Yavapai County case?
We're making a jurisdictional argument, so I guess it's one of those existential questions. Can you appear to challenge the jurisdiction? Is it a waiver to the court's jurisdiction? We're asking this court to hold that the Yavapai County Court did not have jurisdiction to approve of these MOU proceedings, which the SRP and the VERDE ditch commissioners believe that we could be bound by pursuant to the McCarran Amendment. We disagree with that view of the McCarran Amendment, but essentially what we're here with is with a jurisdictional objection, and by making that objection, we're not waiving sovereign immunity.
Something in the nature of a special appearance.
Yes, if that's the way the court wants to look at it. I mean, what we are arguing to the court is the proper forum for the adjudication of these disputes is the general adjudication, where we have waived our sovereign immunity, and we're working diligently to attempt to ensure that water rights ultimately get properly adjudicated. I'm running towards the end of my time. I'd like to save some time for rebuttal, unless the court has questions.
What about the effect of SRP's argument that none of this winds up to being adjudication of water? All it is that SRP will not challenge whatever the decree happens in Yavapai County as part of the Gila River adjudication.
Right. Well, I think if you look at the terms of the MOU, Recital G, paragraph 12.4, it specifically contemplates a consent decree where the Yavapai County Court will enter rulings with respect to essentially the colorization of the land, who has a water right, and then will limit deliveries to that water right. Counsel for SRP admitted in proceedings below that this would be binding on parties that didn't participate, and there's no opt-out. So there would be that binding determination.
That would be binding on the Gila River. Their argument is that it would be binding on the Gila River adjudication?
Well, it would be a binding judgment by the Yavapai County Court, right, and which would govern in the interim. And then, and that's ultimately the problem. Then it gets to the Gila River adjudication, right? And parties who did not participate would have an opportunity, and who wouldn't be bound by these proceedings, would have an opportunity to object and say, no, that transfer of water or that determination is not correct.
Right, but that's a factor. The fact that there's a decree is a factor that could affect the Gila River adjudication.
Absolutely, and also, the Maricopa County Court doesn't sit as an appellate court in review of the Yavapai County Court. They're courts of equal stature, and that's why the rule of prior exclusive jurisdiction is important. You get the case in the court that already has the subject matter of the adjudication to adjudicate it.
So if we were going to agree with you, you would simply say we vacate the order and hold that the Yavapai County does not have Superior Court does not have jurisdiction to approve the memorandum of understanding or other similar agreements among the shareholders.
That's correct, Your Honor.
Can I just ask if yes. The memorandum of understanding didn't have any provision for once 80% properties are in agreement or whatever, that something kicks in that the ditch can shut off water,
right.
Would you still? And I guess that goes to the project's argument that it's not necessarily ripe if everybody agrees on something and nothing happens. Is this premature?
Well, I mean, ultimately, what we're here arguing is essentially a motion to dismiss for lack of jurisdiction. It's not an answer to say, well, at the end of the proceeding, there may not be a judgment because there might be a voluntary dismissal. We may never get there. Now, if you're talking about a question of appellate jurisdiction, none of the SRP and VERDE Disc Company haven't challenged appellate jurisdiction, and we explained in the brief pursuant to Arizona Revised Statute 12-2101 A1, 2, and 4, reasons why we believe there's appellate jurisdiction.
As far as the idea that there may never be a decree, that doesn't answer. I think I understand your argument to be that doesn't answer the question of does a Superior Court even have jurisdiction to consider this.
That's right. I mean, they're moving toward a consent decree, and obviously they would also be asked with respect to sever and transfer agreements to make binding determinations, which take immediate effect. They're to be recorded, take immediate effect, and govern how the VERDE ditch would be run prior to any final consent.
I'll let you reserve the rest of your time.
Thank you, Your
Honor. Morning, Your Honors. May it please the Court, Mark McGinnis from Salmon, Lewis, and Weldon on behalf of the Salt River Project. I'm intending to reserve some of my time for Mr. Mayberry from the VERDE ditch. I realize that's my responsibility to do that. It's between he and I. I want to start with answering two of the questions that you asked Mr. Smeltzer that I don't think he quite got answered for you. The first one was your hypothetical about if you had two private landowners who just wanted to tinker with the shares a little bit, could they go to the Yavapai Superior Court to have that approved? And I think not only they could, as a practical matter, they have to. Mr. Smeltzer's answer, I think, shows a fundamental misunderstanding for what we're doing here.
I thought he said yes.
I thought he said yes too.
Well, I thought he said he wasn't sure they had to. He wasn't sure they could.
Well, or they had to. But
Yes.
but all we're talking about is landowner A, landowner B, 10%, 9%. I'll give you one of my percentages.
Yes. Not only can they have to. That's my position. And if I misunderstood his, then I apologize. But I think they have to, and that's because the judge, through the commissioners, is the master of the ditch. So these things, when they get moved around, the ditch has to know about them because they're the ones that deliver the water. I mean, we can talk all about jurisdiction and legal precedent you want, but this guy, Judge Mackey, is up there running this ditch. I mean, he has meetings with the ditch commissioners. He runs the ditch. It's a practical matter. He has to. The second thing that Mr. Smeltzer couldn't quite answer for, you answered maybe differently than I would be what happens if you're okay with jurisdictionally with everything except for the final settlement agreement? And I think that's a good question. This memorandum of understanding is the product of years of work by not only SRP and its staff, by the commissioners, by Judge Mackey, who's had several conferences, status conferences on it, and several of the landowners have been involved. And we think it's very important that we know what your opinion is specifically as to those things that Judge Mackey thinks he's going to do. Okay? So there are 6 things that we think Judge Mackey either is doing or contemplating in the MOU. And I wanted to walk through those, each one of those with you, because to the extent you think there are things he can't do, we'd like your opinion to be very specific about that. We think he can do
and to
all
be
of
clear,
that.
I'm looking forward to the recitation, but to be clear, you're not suggesting that if Judge Mackey can't do them, they can't be done, and that all the years of work would be thrown out. I mean, ultimately, wouldn't you agree that this case is just a question of the proper forum?
Well, in certain ways, yes, and in certain ways, no. The adjudication of the water right, I agree completely that the proper forum is in the Gila River adjudication. SRP filed it 43 years ago. We've spent millions of dollars. I spent 27 years of my career primarily working in the adjudication. There's a hearing going on right now down the street in the adjudication.
How's that working out for you?
It's working out better for me than my client from a financial perspective. But there are certain things with this MOU, and I wanted to walk through them if we can. I'm trying to answer your question. Sure. The first thing, and the only thing that he really has done in this order, specifically that happens today, or as soon as if you affirm his decision, is he authorizes the commissioners to enter into the MOU. That's one. The MOU, we believe, is a process document. You talk about purple, green, and orange lands. The reason for the purple, green, and orange designations, from our opinion, is to figure out which type of agreements SRP is going to try to negotiate with which landowner.
But the MOU, as I understood, at least the VERDE Ditch's brief, is sort of a dead issue. And there may be agreements, but it may not be through the MOU.
I don't think that's true at all.
Okay.
And I would point you to the transcript of the hearing with Judge Mackey on June 16th, 2016, which is 626, the index of record, where Judge Mackey, and I'm trying to be as kind as I can, but Judge Mackey basically says, you guys work for me, and I really want to get this done, and we'll figure out a way to do it. It might not happen
So
as
regardless,
quickly.
okay, so he's still, Judge Mackey, as the master of the ditch.
He is by far the master of the ditch. And the real problem that the commissioners were having with it was purely financial. And
But
frankly,
I assume SRP could fund that.
we haven't done, well, we've done a lot of the work, but, you know, there's certain things that the ditch has to do itself.
It's the first one of the 6.
First one of the 6 is just approving the process.
Right.
The second one is that the judge authorizes the commissioners to enter into the historic water use agreements as a party with those people who have entered into agreement with SRP. SRP says, you have green lands, we recognize you have green lands. The landowner says, yes, we agree we have green lands, and these are the lands we're going to irrigate. The ditch commissioners are a party to that agreement only because they have to be. Again, they run the ditch. We would do these by ourselves with just the landowners, but the judge has this continuing jurisdiction, and he runs the ditch.
And those would be determining historical water usage.
Those would be voluntary agreements about where the water has been used. It would not be determining, well, it wouldn't be an adjudication, wouldn't be a litigation
it's an
of those.
agreement.
Right. The judge would be approving those as in his role as the master of the ditch for purposes of where he delivers water.
But wouldn't such an agreement have an effect on others who are not party to this process document?
I don't see how those agreements could have, the green agreements, let's talk about those to start with, could have effect on other people. The other parties to the adjudication aren't bound by those. Those are private agreements between SRP and the landowner.
Once the court approves them, could it affect?
To the extent another party to the 1909 judgment thinks, oh, SRP thinks you're green and you think you're green, but I don't think you're green, that's where the court approval process comes in if they want to come in and object.
And
we don't know
then,
if that's going to happen. Sorry,
and if a court approval process happens, you're envisioning that being in Yavapai County, right?
As to approving those particular agreements.
Right. And doesn't that far exceed the scope of the 1909 judgment?
All the judge is doing, the judge operates the ditch. The answer is no to your question. He operates the ditch. All he's doing is approving a private agreement that we could have made otherwise as the master of the ditch. You got to separate, and I know this is difficult at times, but you got to separate the judge's role in this particular unique situation that is not the only one, but there aren't very many of them, where the judge has this continuing jurisdiction over the ditch versus what we normally think of as a Yavapai County Superior Court judge.
The regional agreement, the 1909 decree, simply says, I've got a fractional interest in the ditch. I'm a 13% shareholder. That means I got a 13% interest in whatever happens to be at that moment in the ditch, the water in
Yes.
the ditch. Now the judge is going to say, based on your historical water usage, you guys have entered into, you shareholders have entered into agreement that this is your historical water usage, and I'm going to approve that.
And what that means is, yes, and what that means is the percentage right you have in the ditch, this is where you can use it. It doesn't bind non-parties or other people in the adjudication to say this is a water right. The word water right is only in the, I'm sorry, the word water right is only agreed in one place, and that has to do with if there's not enough purples to cover the oranges and we have to go outside the ditch. In that case, I think you do have to deal with water rights because you're outside the scope of the judgment. Sorry.
You said that you're talking about a process that contemplates where you can use water that is in the ditch.
Yes.
And the places you can use water that is not in the ditch was not an issue even remotely presented in the 1909 judgment.
Well,
right?
it was to the extent that the shares were done by landowners who were using water. And the real problem with administration up there is to figure out where those people were using water. That's why the historic water use is there.
The question back in 1909 was a very narrow one. The world was a simpler place, and there was an allocation of responsibilities based on certain assumptions of flows, not quantitative assumptions, but just factual assumption of flows, and that's where the judgment started and stopped. I don't see how the questions that have become legally relevant since then are necessarily within the scope of that original judgment.
Again, I keep coming back to the master of the VERDE ditch. In order to know where the shares are today, you went from 12 people to 600.
The master of the ditch is a grand title, and it sounds impressive, but it's still limited by the terms of the 1909 judgment. The master of the ditch does not necessarily mean that you're the master of all consequences of the ditch that were not contemplated in that judgment.
That's correct. I agree with that. But he has the practical obligation to operate the ditch, and in order to deliver the water, he has to know where the shares are. And that's I don't know how else you do it. I mean, you just got to think on the ground running the ditch. You got to know where the water's going.
I only got to 2 of your 6. I mean,
Okay, that's.
I'm sorry.
No, go
I'm
ahead.
looking forward to the orange.
And Mr. Mabry's counting my time, I think. So let me run through the other 3, and then we'll.
Okay, now
other
is
4.
your second point only on the green lands?
The second point is on the Greenlands. 1 was the authorizing the MOU in the first place.
Right.
2 is the approval of the HWU private agreements. That's in 7.2 of the MOU. 3 is to approve voluntary severance and transfers, and that shows up in 7, 8, 9, and 12 of the MOU.
And is that
Those Pardon me?
Go ahead.
That's 3. 4 is the reconciliation of the shares after the S&T's severance and transfers have happened. That's in 10 and 12.6. 5 is resolving disputes about who's orange, who's green, and who's purple, and that's in 5.4. And 6 is if we get there, if we get between 80% and 100% of the lands done by either a severance transfer agreement or a historic water use agreement, to approve the final settlement agreement and to review those sort of things that are still orange as part of the final settlement agreement. And that's what Mr. Smeltzer talked a lot about.
So if that, okay, go ahead.
And that's 12.1 and 12.4. That was your question about what happens in the final settlement agreement. Again, if there are two targets, 2 numbers really, in terms of getting the final settlement agreement. If we don't get to 80%, the final settlement agreement never gets drafted or proposed. If we get to 100%, then essentially we don't need it because everything's been done voluntarily. It's between that 80 and 100% where the judge, and this really essentially came from Judge Mackey more than SRP, I can tell you that, he thinks we're going to resolve those other 20% if you guys can't take care of it. That's where it's at.
And so if one of the landowners doesn't reach an agreement under the MOU, the ditch could shut off the water to that person.
And it's important to think about the timing on that. Yes, but not yet. I mean, there's nothing during the pendency of the MOU that causes a consequence for somebody being orange, even if they don't think they're orange.
That is a consequence that's contemplated under if you reach 80%.
The consequence that's contemplated if we reach 80%, get to a final settlement agreement, the consequence is that person, before they got shut off, would have to go prove up the fact they've been using water on this land historically to Judge Mackey. That's number 6.
Isn't that an adjudication of?
Well, I would agree that's the closest we get. It is not an adjudication.
It's not an adjudication.
Well, again, having dealt with adjudication for 27 years, adjudication deals with priority date, which this doesn't deal with, the judgment didn't deal with, we don't deal with. It deals with purpose of use, which this is not dealing with. It deals with season of use. There's actually 12 attributes of a water right.
Does it deal with historical water use?
Pardon me?
Does appropriation deal, was one factor in appropriation historical water use?
Certainly.
Okay.
That's true. So of the 12 elements of a water right, number 6 on my list gets the closest to one of those 12. I'll agree with that. And frankly, and again, what I said earlier was these are the 6 things from SRP's perspective, and Mr. Mayberry, I'll try to give him some time to talk about this. From SRP's perspective, if you say number 6 is outside his jurisdiction but the other 5 aren't, we're going to go back with Mr. Mayberry and the commissioners and Judge Mackey and try to craft the MOU to work so we can keep this process going. It's been a long process. I don't know if you know the history of SRP and the Verde Valley folks, but there's been at least one decision by the Court of Appeals over the last 50 years. It was very contentious for a long time, and SRP really had a sea change in terms of the way they looked at this thing about 2010, and it was gradual leading up to 2010. And what we're trying to do is meet with these folks. You know, if you look at the numbers here, if you look at the numbers in Section 5, the numbers of purple, the acreage of purple and the acreage of green are almost the same, right? I mean, that's the revelation we had, is they're just using it in the wrong place. The total amount of water acres, at least, is about the same. So I will yield the rest of my time to Mr. Mayberry unless you have other questions specifically for me.
Thank you.
Thank you.
I'm Rick Mabry here on behalf of the Verde Ditch Company, and I'd like to just make a couple of points that I think are important to understand where we are. Judge Mackey has made it very clear that, depending upon obviously the ruling from this court, that the commissioner's decision that they couldn't financially continue in the MOU process, the judge made it very clear on the May 24th, 2016 hearing, which is page 25 of that particular record. He said, I support your decision at this point not to consider signing the MOU in the immediate future, but I do agree with SRP's position that this should not be a final determination, that let's review that matter at the conclusion of the appeal process. And the reason that it's important is, frankly, that what's happened since 1909 has been this multitude of splits and divisions and such of properties along the 18 miles of the Verde Ditch, that now we have a lot of people saying we have a right to use the water because we think we have a historical water right. And what became very clear to the Verde Ditch commissioners 15, 20 years ago is the records that the Verde Ditch Company has been able to cobble together over the years based upon the voluntary, actually it wasn't voluntary, the court ordered it in 63 and again in 89, that the shareholders were supposed to provide the information to the Verde Ditch Company to be able to say, hey, we're selling this or we're doing this. As a result, the Verde Ditch Company, in looking at its records, especially knowing that the adjudication at some point in time will come into the Verde watershed, determined that there were a number of questions about historical water uses that they were assessing people for, that they had assessment records, but they had no way of dividing or deciding how that related from the historical water uses under the 1909 decree.
Wait, how does you lost me on that last one.
Mm-hmm.
How did the 1909 determine historical water usage as opposed to just a fractional interest in the ditch?
What the 1909 originally started with were the original homesteaders that had filed. And when they did, they filed under some sort of agreement as to their acreage or use. The 1909 decree simply put a fractional share, but we know that the water code, until the water code of 1919, did recognize that you could use a beneficial use. So we had people subsequent to 1909 and that original decree that started using water from the Verde Ditch and may have a valid historical right.
Certainly. And you would agree that that could be determined as part of the Gila River adjudication?
Absolutely. As to a vested water right, we believe that has to be determined.
I think you make valid observations as to the historical context and the issues that need to be decided. But as I compare the points you make to the language of the 1909 judgment, I struggle to find a connection.
Well, I think you have to look at the court's interreaction since 1909. There's been over 280 filings since this action was originally started to the date of the filing of the MOU.
How many of them dealt with appropriation of water?
Most of them dealt with whether this person was paying their assessment or how they were going to have a commissioner appointed.
Which seems directly related to the terms of the 1909 judgment. But all the things that you've mentioned today seem perhaps to involve the 1909 judgment as one element of a property interest, but they don't relate to what the court was asked to do in the 1909 judgment.
Correct.
That's my concern.
Yes,
If
but
they don't relate to what the court was asked to do, then how can the court have continuing jurisdiction over something over which it never asserted jurisdiction?
Well, we think that the court did assert jurisdiction under the 1909 decree to be able to deliver water to those that were entitled to water from the Verde Ditch. We think that was the original jurisdictional determination by Judge Sloan in 1909.
But
that
Judge
just goes to
Sloan's,
shares and not a right to the water.
Correct.
the Judge Sloan's judgment expressly assumed out of itself the notion of actual flows or actual quantities of water.
It did, because the water flows were so seasonal and fluctuated so much that the court did not have the ability to make any of those other determinations.
Understood.
And so that continuing jurisdiction is continued.
Could I just ask one question? If we if we were to find that the last provision, the 80% requirement, and then the ability of the court to come in and cut off water, if that were not part of the agreement, does the master, is it necessary for the court to be involved for the other types of negotiations that the Salt River Project wants to undertake?
Well, we think that it is important for the court to be able to give the direction to the commissioners of who should be receiving water or entitled to the benefit of water. As Mr. McGinnis has indicated, we're not trying to adjudicate vested water rights because those have multiple attributes that we're not involved with whatsoever. So the key for the...
Can you make that determination without making the vested rights determination?
Yes, because all we're doing is using historical water use.
That's a factor in appropriation.
It is a factor in the appropriation. There's two factors that we have a part of this agreement that would be one of the multiple factors of a vested water right. One is a historical water use, and secondly is the place of use.
Isn't historical water use disputed in some cases?
I'm sorry?
Isn't the concept of historical water use or the amount of historical water use disputed in some cases? It's not that like there's a table of historical water use that everybody agrees on and is established. These are things that have to be analyzed.
Correct. But the historical water use, if we can show there was a use in those early years to a particular piece of property, everybody's green. We don't have to worry about all the other attributes that the adjudication court will be dealing with as to, continuous use, subflow, all of those kinds of questions that arise, forfeiture, abandonment. We're not dealing with those.
But then you're talking about agreeing upon facts that are relevant to important legal issues today that the 1909 judgment completely and expressly excluded from its scope. So why does that belong in Yavapai County?
Because we have a master of the VERDE ditch that's in charge of making sure that there's sufficient water delivered through the ditch.
Where does the 1909 judgment say that the master is responsible for a sufficient flow to the ditch?
It's inherent in the powers that the court has exercised since 1909.
Okay.
We've got, 36 miles of ditch bank to maintain, and we've got to have some mechanism to be able to do that, and that's what the master of the VERDE ditch has exercised over the years.
Okay, thank you very much.
Thank you.
Your Honor, just to pick up where Mr. Mayberry left off, we would say that in the interim, what the master and the commissioners ought to do is just ensure that water is delivered in accordance with the terms in the 1909 decree, the 1963, and the 1989 regulations. The concern with historic water use is not coming from a necessity to change those rules as to the users on the ditch. It's coming from folks outside the ditch that have competing claims against users on the ditch.
So SRP said there were 6 components
Right.
he wanted us to address. So Judge Mackey would know what he could do. And as I assume your position is Judge Mackey can't do any of those 6.
That's pretty close to correct, Your Honor.
Any one of those you say
Well,
you could do?
the problem with trying to unpack them, Your Honor, is because they're all leading towards a particular goal, right? And they start with a working understanding between an agent of the court, the commissioner, and an adverse party, the SRP, that the allegations are true, right? That there's not historic water use. So now you have the people who are actually using the water being told by the court that you don't have water rights and you better come in and do this. And that's coercive in effect.
Every part of the process really needs to get adjudicated in, of the 6 parts, needs to get adjudicated in the Gila River adjudication?
I would believe so, yes, Your Honor. I mean, there are certain things that SRP might be able to do with individual water users to reach agreements, and I don't want to explore the full extent of those things, but the items that are ticked off are all related, right? They all in toward a goal. And I also want to draw the Court's attention to one of the interim items. I think it was number 3 on the list, but the sever and transfer agreements. Because in addition to talking about taking, I believe it's purple to make orange green, I'm not sure how the spectrum makes that happen, but you know, with respect to that process, if there's not enough purple to make orange green, part of the MOU is that we're going to go outside the VERDE ditch area and find other rights that might be transferred in, and that the Yavapai County Court is going to have jurisdiction over those as well. Ultimately, right, the folks that might have an objection to a sever and transfer agreement, and of course when you sever and transfer a right, you don't just sever and transfer an attribute, historic water use, you sever and transfer the whole right, and you need to know the date of priority, the amount of use, and those things to do it and to allow other people to make objections. But there are people throughout the Gila River system that might have objections to those rights that aren't part of these proceedings, and you'd have the court, you know, making that determination in a piecemeal fashion and not in the court that really has the jurisdiction to do that.
If SRP were just able to reach agreements with everyone, and there's no need for a final decree, you're saying that, so your position is that that would have an effect on other people's rights if they've just reached voluntary agreements?
Not just the agreement, Your Honor, but ultimately if they want the agreement then, you know, to become part of the overall decree in the Gila adjudication, for example, that would have to be presented to the Gila court, and other people could raise objections. Because if there's, say, a voluntary agreement to transfer water ultimately, other parties and other places in the system get to say, has that right been abandoned? Was it truly perfected? You know, there are issues that
understanding
arise.
that it's not binding in the Gila adjudication, but is there some reason? And
well, if it's not binding in the Gila, I don't know where it would be binding. I mean, the Yavapai.
It's binding as between them, just the parties that enter into an agreement, and as against no one else. But is that, if that's something they want to explore without any kind of, with making clear that it has absolutely no effect on any other?
Right. Well, if it doesn't affect an order from a court or a commissioner appointed by the court as to where to deliver water, you know, there's freedom of contract. But as long as you're involving the Yavapai County Court, where the court is saying, you know, look, there's been a transfer of water rights, there is a water right here, or that you can only deliver to this land, you know, you've got the court making a determination on a water right, and those determinations are not part of the 1909 decree and belong to the Gila court.
It's just signing off, just saying the parties have agreed, and as the person who's managing the ditch, we need to know that, and so, okay, we understand you've reached an agreement.
Right.
If that's the extent of the court's involvement.
Again, as I understand it, parties have always been able to transfer shares in the ditch, and that will change delivery pursuant to the original terms of the 1909 decree, and that's fine. I'm not sure that Mr. McGinnis is right that they're required to take that to the court. They've never been required to take that to the court before, and I don't know that the MOU makes that a requirement, switching a share. The MOU deals with something completely different, right? That's not related to who holds a share. It's related to who has a perfected water right, and that belongs in the Gila court.
Could you be severing and transferring water rights?
Right.
Okay.
Thank you, Your Honors.
Thank you very much. Appreciate your arguments. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.